Hi, everyone. I'm Maggie McGrath, senior editor at Forbes. Yesterday, the Supreme Court heard arguments surrounding the Trump administration's tariffs, and many members of the bench appeared skeptical about the administration's arguments around its ability to implement these global tariffs. Joining us now to discuss the Supreme Court hearing and the arguments we heard yesterday is Jonathan Todd. He's a partner at the law firm Benesch. Jonathan, thank you so much for joining us.
Thank you, Maggie.
So, for folks who maybe haven't been watching this as closely as you have, can you give us the 30-second overview of what the case argued in front of the Supreme Court was yesterday?
Right. So the case centered on these reciprocal tariffs that everyone's been talking about all year long. Also, the tariffs for fentanyl trafficking and for immigration. The government presented its case. Certain small importers presented their cases, and some states presented their case as well. At the heart of this was a balance of powers question. At the heart of it was we understand that tariff power rests with Congress. We understand that foreign affairs rests with the president. And we understand that there's legislation, there's a statute called IEPA. And so the question was whether Congress granted powers to the president to do what the president did this year.
Now, earlier this year, we had a number of state attorney generals and governors mount lawsuits against the administration. Is what happened in the Supreme Court yesterday a result of that litigation, or did this come from a different party?
There are a few cases, there are two in particular that kind of yielded where we are now. But the question is fundamentally the same. The question is, we have importers in the United States, across the United States, who are paying tariffs for basically every import from almost every country around the world, and these have changed dramatically. And the question is whether those burdens that were imposed on importers were appropriate. And it really gets down to exactly what Congress empowered the White House to do under this IEPA statute and whether the White House rolled out these tariffs appropriately.
Now, you've mentioned that at the core of this case is a question of administrative executive power. Power is, of course, an important thing to examine, but what are the financial outcomes or the potential outcomes of this Supreme Court case? I was reading somewhere that the administration could have to potentially pay back billions of dollars in tariffs. Is that true?
Right. So the interesting thing from my perspective with the oral arguments that happened yesterday is it seemed to be almost a consensus of many of the justices that tariffs are in many ways equivalent to a tax. And one of the points of discussion that was heated was whether that is the case and whether there's a financial motive for the federal government to impose tariffs in this way. There have been billions and billions of dollars collected. The amounts collected haven't really reached what were anticipated, but there's a great sum of money that have been collected. And if you think about the potential outcomes, there are really three things that could happen, right? The government could support the tariffs as they were rolled out. So that's maintenance of the status quo. Companies will still need to pay duties in the way that they have been for imports. The government could strike down the tariffs, which then raises the question of refunds. And then there's a third option, which it could be that IEPA allows tariffs to a degree, but that it's maybe somehow tailored on what the White House can and can't do under that statute. But if we focus on that second option, if we focus on the possibility that these tariffs were essentially unlawful in the way that they were rolled out, there were billions and billions of dollars collected in duties on these tariffs, and it raises the question of whether those will be refunded. Justice Amy Coney Barrett referred to that potential as a mess, and that no one exactly knows how that would work, what the process would look like, and the administrative burden seems kind of great. There was one comment during the oral arguments that if there is relief, maybe the relief is only prospective. Maybe going forward, importers no longer have to pay those duties, but maybe the monies that were collected do not have to be refunded. So if that happens, if this is completely overturned, these IEPA tariffs, then the question of what happens with the monies, and from my perspective, if you're talking with importers, the question of, okay, how do I get those monies if I paid them and they were unlawful? That still remains a big open question, and in Justice Coney Barrett's words, potentially a mess.
Potentially a mess. We'll get more into the outcomes, but because you're talking about oral arguments and what was said, let's dive into that. A lot of the coverage resulting from yesterday's oral arguments cast the Supreme Court as generally skeptical of the Trump administration's arguments. What were your impressions of the questions the justices asked and the general tenor of the arguments?
So this is a little wonky, and I'll accept that. But for anyone who's interested in textual analysis and the history of laws and the balance of powers in our country, it was a very interesting argument. I found it very interesting. It was clear that the justices were taking this seriously and were kind of giving a full-throated review of all aspects that are at issue here. And that includes even textual review, the question of exactly what words mean and how words have been used elsewhere by Congress with similar or different intent. And fundamentally, constitutional issues of exactly what did the founders intend with the balance of powers between the presidency and the Congress. It was very thorough. There were also many hypotheticals that were played out, which were kind of interesting. One hypothetical was that, supposing that the White House is correct and IEPA does empower it to do what it did, then in theory, a future administration could, let's say, take on the purported climate crisis. And the government, noted that, this presidency would not do that. But if a future administration did and chose to significantly tax the imports of internal combustion engines and parts and do, efforts like that to combat that emergency, then that would be permitted under the government's argument here. And the answer was that that is true, that a future administration could take that position and use the statute in that way. So it's really, really interesting, really, really textual, and it has big implications for what White Houses in the future may do. And, Congress is still in this mix. Congress can still legislate, they can still exercise their authorities. So it has implications for what happens in Congress and with legislation going forward.
That's really interesting. So even though this case is centered around executive power, Congress proved to be a factor in our oral arguments. So could this case affect the way Congress ultimately vetoes presidential power, or at least when it comes to tariffs?
So those points were discussed, and I think what's very interesting from almost a patriotic perspective, and again, not to be too wonky about it, but there's a lot of frustration in America about Congress, and there has been for years. This isn't news to anyone. And one thing that was clear here is that Congress does still matter, and Congress needs to legislate. And the exact language of legislation that's produced by Congress also matters. And I think that's good perspective. That's healthy for us as a country, right? To recognize that we need the legislative branch to exercise its role in governing in this, three-part government system that we have.
Now, as I was reviewing some of the reporting from the oral arguments, it seemed to me that some of the justices were also focused on history. And of course, precedent factors into almost every Supreme Court oral argument. But I saw references to Nixon and 1970s law. What was your impression for how much precedent played into the way the justices are thinking?
Yeah, so the root of IEPA was something called the Trading with the Enemies Act, and President Nixon famously closely aligned with the act. There was a question of whether Nixon exactly relied upon the act, or if the act in some way essentially mirrored what President Nixon did. But there was a period in time when President Nixon imposed a limited value of duties on imports for a limited time. And this was aware that this was aware to Congress when the Trading with the Enemies Act was written. And of course, that history of how the Nixon administration rolled out tariffs was known when IEPA was crafted. And so the position of the government was that Congress knew exactly what it was doing. Congress knew that the Nixon administration had used tariffs in the way that they had, and that the language that's at issue here in a way supported that. And so that in one way goes to congressional intent. The interesting thing about the here and now is that, as Justice Roberts said it, the current interpretation essentially yields the ability to impose any tariff on any country or every country at any time and at any magnitude. That's a loose quote, but it's very close. And that really is the question here because that's the experience of businesses and of importers over the last year. These tariffs seem to come out of nowhere for most people. They would go up, they would go down, they would be on, they would be off. This really has been our experience. And it's in contrast to what happened during the Nixon administration, where although there were tariffs imposed by the White House, there was a cap on the amount of tariffs that were imposed. It was for a limited period of time. So it really becomes a question of, even if that was the history, was that the intent of Congress under the current legislation? And then specifically, what was that intent? It's not just solely a question of whether tariffs are permitted, although much of the oral arguments focused on that question. It's also a question of whether they were permitted in this way, that essentially any tariff could be imposed on any country for any period of time in any magnitude. And that's fundamentally, from a business perspective, what many of my clients have been struggling with all year long.
Talking about clients struggling, I went into a coffee shop in the West Village yesterday, probably around the time that oral arguments began. And on the screen, it literally said tariff surcharge. And I hadn't been to this coffee shop in a number of months. It turns out that in September, this business instituted a small 1.5% fee to help account for the tariffs being levied against the beans that this business is importing from coffee making countries. I don't want to misquote which countries, but we've seen how vast these tariffs are. So I do recognize that yesterday's oral arguments sounded like they were focused on procedure and precedents, but was there any conversation around the effect on American businesses and what this is doing to small businesses, medium-sized businesses around the country?
Right. There were both personal and kind of corporate level points of discussion. So from the corporate level, there were questions from the justices about who exactly pays tariffs. And the government's response was kind of in keeping with, the president's position, which is that foreign countries pay. The government's response was that even if a domestic importer of record actually writes the check, that domestic importer of record is negotiating, purchase agreements with its foreign suppliers. But the fact of the matter remains, domestic parties are writing the check first and foremost in most instances. And on the personal individual level, this leads into the conversation of whether tariffs are actually directly akin to taxes, whether they're almost one and the same. And there was a point of discussion during the oral arguments where the kind of interesting just coffee table perspective of if I'm going to be taxed as an individual, I would like to know that my legislature discussed this, negotiated it, both House and Senate, agreed upon it, and something was passed. Not that it was just unilaterally decided by the executive. And I think that for those who are feeling the pinch, and I realize maybe that's not everyone or not everyone's aware of it, but for those who are feeling the pinch, I think that is kind of the perspective that this is a burden paying these duties, and it does seem to have happened kind of just by the unilateral decision of the White House, and that's a challenge as well. There's one more thing that we should bear in mind, Maggie, which is that these reciprocal tariffs based upon IEEPA are not the only game in town. So all year long, especially for niche industries like automotive is the classic example. There have been other tariffs. You hear them as the 232 tariffs. If we go back to the Trump 45 administration with the 301 tariffs on imports from China, there are other statutory measures available to the White House that are far stronger from a legal defensive position than IEEPA, and the president is using those. So this is kind of a crystal ball. There's really no way to read either the outcome of the case or how the White House will respond. But my perspective is that there are many tools in the toolbox still available to the White House, even if this were overturned. And this president loves tariffs. He says that tariffs are his favorite word. I think it's fair for businesses and for people to expect that tariffs are largely, here to stay in the near term. Maybe not in this form, maybe in another form. But we will be hearing about tariffs for much of the administration. They will be exercised. And going back to the automotive example, each of the large automakers have announced that they're being hit, on the magnitude of a billion or billions of dollars because of tariff burden. So this is real. It's here to stay, although reciprocal tariffs are certainly an open question right now.
I think that's a very fair and good point. And to that point, I would ask, is this, if you zoom out, one of the more important economic cases that the Supreme Court has taken up in recent years? Is that fair to say?
That's certainly the consensus. It's important from an economic perspective. It's also important from just the foundation of our country, that the idea of co-equal branches of power is fundamental to the American style of government, and that's really what is at issue here. It's very serious. The president has said a number of times that this is the most important case ever, that the future of a golden age of America rests on this case. And has even used, if I recall correctly, used words like the Depression, the Great Depression, that this could lead very bad places fiscally, if the reciprocal tariffs are overturned. That's opinion. We will see what happens. And again, there are other measures available to the federal government, but this remains a very significant case. And you're also seeing that in just the media coverage, right? There's a great deal of interest in this, and kind of more interest than you would historically expect in exactly what justices said and how they said it here in the days after oral arguments.
It's an interesting point, though. There is a ton of interest, and it might be a little wonky, but I also think if you zoom out and you look at the Supreme Court, you look at the composition of justices on the bench, and you look at recent precedents in other cases, not related to tariffs, but perhaps to immigration. You've seen a court that has generally been unwilling to challenge President Trump in his second administration. And this is perhaps more of a political question than a policy question, but do we think this is the moment that the judicial branch of government uses its full might to perhaps counterbalance actions in the executive branch?
So this really is, the balancing question, right? On the one hand, most of the conversation focused on textual analysis and history and hypotheticals of what this means. And that's really, vetting out, what the justices are comfortable with and how it aligns with their understanding of law and jurisprudence in America. On the other hand, and this is kind of more in the government's favor, there's the question of what we expect the executive branch to do if there is a national emergency. Because remember, this is fundamentally a national emergency statute. And it was clear from some of the commentary that there's an understanding that certain unforeseeable events may happen that require a White House to respond in ways that must be faster and more aggressive than Congress could ever mobilize, and that the White House needs to be empowered to do so. And at its core, that's essentially what Congress was trying to do here. So that question of whether the White House has, space, conceptual space to do what it needs to do in its view to protect the country versus, intent of legislation and intent of Congress and of the Constitution and the framers, that really is the fundamental balance that we'll see play out when we have a decision.
So speaking of when we have a decision, I'm going to ask a calendar question first. So it's early November. Oral arguments were yesterday, November 5th. What are the next steps in terms of the Supreme Court schedule? Is there a deliberation time? Do we know when a decision's coming? What do we know?
Yeah, so we kind of know near term and long term, and we don't know anything in between. Near term, there's the possibility, since this was heard on an expedited basis, there's at least the possibility that a decision could be delivered yet this year in 2025. On the outside, we know that a decision will be delivered by June of 26. That's when the Supreme Court's term ends. So if you had to bet on it, and this is exactly crystal ball stuff that no one can really gauge, but if you had to bet on it, we should have a decision, end of year or into next year.
And then the other crystal ball question that I have to ask, given the skepticism that sounds like emerged from the questioning in Chief Justice John Roberts, Justice Amy Coney Barrett, is there a way to kind of calculate how this vote might go?
Yeah, I've just personally never been a fan of trying to do that predictive analysis. I will say this though, there's a great deal of reporting out there right now about the predictive markets, and on what folks are truly betting the outcome may be. The last time I looked, the vast majority of those were anticipating that the government's tariffs would be overturned in this case.
And even though the president has called this a tremendously important case, to your point, there are still other tariffs that he could levy. So, how important is the ultimate outcome of this particular case, in your opinion?
I think for this president, it is very important that's not untrue. On Inauguration Day, he announced his America First policy for global trade. He has been all around the world all year long trying to make trade deals happen. We have some very nice framework agreements. It really has, changed global order, but that's due in part to the threat that we saw on Liberation Day on April 2nd, 2025 when these worldwide tariffs were announced. And so if these were no longer available to the White House, it's fair to think about what countries may then be willing to engage in these kinds of negotiations, the degree to which they'll be able to engage in these, and exactly what leverage the president has. And this isn't super hypothetical either. We're at the end of 2025, and next year in 2026, the USMCA will be renegotiated, the old NAFTA. So we'll be negotiating with Canada and Mexico on what the future of the USMCA relationship looks like, whether there will be tweaks. There was a comment period this fall where companies, domestic companies, can really tell the government what it expects to see with USMCA. And this is kind of the near term, challenge or a really great example of it that I see. If these are overturned, and that means that the president does not have freedom of movement like the president did in terms of negotiating and using leverage in these kinds of agreements, then that very well may change the way that we approach all negotiations around the world, but in particular those that are right here in our backyard, like USMCA. And so 2026 could be a very interesting year in terms of international relations, depending on how this plays out.
Jonathan Todd, partner at Benesch, thank you so much for joining us to talk about the Supreme Court case around President Trump's tariffs. We'll have to have you back as a decision nears or even after a decision comes. But in the meantime, thank you so, so much.
Thank you, Maggie. I appreciate it.